Hello viewers, welcome back, and I hope you all are doing well. And I'm back with one more video for you all. And from my thumbnail, it is clear that today's topic of discussion is on marital rape. And but before starting with today's discussion, let me inform you all that three videos on CRPC have already been uploaded in the channel. So please go watch those videos and give your appreciation to it if you liked it, and also give your suggestions with respect to any improvement that is required in the quality or the content of the video, and I'll definitely accommodate those suggestions on in my next videos. So now let's start with today's discussion. So this topic of discussion was chosen by me in this video because a lot of recent legal developments are taking place around this topic. And the most important one is the judgment delivered by the Hon'ble Delhi High Court in the matter of RIT Foundation and others versus Union of India, wherein a split verdict has been passed by the Hon'ble Delhi High Court with respect to the constitutionality and legality of the exception of marital rape enshrined under Section 375 IPC, Exception 2. So, viewers, before in this video we will elaborate on this judgment, and before doing so, let me introduce you all to the concept of marital rape and the concept of rape as is defined under IPC. So viewers, the ambit and scope of the offense of rape is defined under section 375A to section 375D of IPC, wherein certain acts are mentioned which constitutes the offense of rape. So if those acts are committed by any man against a woman, then then that man will be charged with the offense of rape and will attract the penalties and the imprisonment given under section 376. And along with the subclauses A to D, there are certain explanations attached to section 375 as to with respect to the other contents of the offense of rape. And but we're not concerned with those in this video. We are only concerned with the exception 2 to section 375 IPC and the general understanding of the offense of rape. So. Uh, so apart from the acts mentioned under section 375A to D that constitutes the offense of rape, section 375 also includes an exception in the manner of exception 2 to section 375 IPC, which categorically states that if the acts mentioned under section 375A to D are committed by any husband against his wife, then such act will not attract the offense of rape, and that act will not be termed as rape as far as that act is committed by any husband against his wife. So I know that now you all would be thinking that this particular exception is kind of a facade in itself, and in my opinion also uh, if you guys are thinking in this particular direction, then your opinions and your and the ambiguities that are surrounding you is are well explained, because because सोचने वाली बात ये है कि just because a person is in a marital relationship, सिर्फ क्या इस रीज़न की वजह से किसी पर्टिकुलर ऑफेंस को हम निगेट कर सकते हैं, या एक किसी पर्टिकुलर ऑफेंस को जो इतना हीनियस हो, विच इज़ अ क्राइम अगेंस्ट वुमेन ऑफ द हाईएस्ट नेचर, क्या सिर्फ इस रीज़न की वजह से कि वो अक्यूज्ड पर्सन उससे उसका हस्बैंड था, सिर्फ इस वजह से क्या उसको एक शील्ड या उसको एक प्रोटेक्शन दिया जाना चाहिए विद रिस्पेक्ट टू द acts that he has committed? Now, as simple as that it sounds, there are certain complications attached to it also. The complications attached to terming the offense of marital rape as an offense is that since the institution of marriage is involved with it, so it makes a bit complicated to draw your opinions of any offense that has occurred during the subsistence of the marriage, because the voluntariness and the involuntariness attached to it is very difficult to ascertain. So, so these were the questions that make the crux of the matter of the that was uh, the decision that was passed by the Delhi High Court also. So we'll now discuss the decision rendered by the Delhi High Court. So we'll divide this discussion on the judgment. Uh, Firstly, based on the arguments that were advanced by both the parties, and then we'll discuss the split decisions that were delivered by both the judges, by that is by Justice Shakdar and by Justice Hariharan. So the Justice Shakdar actually passed the judgment against the exception, that is exception of marital rape, wherein he held that this exception is unconstitutional and illegal, while on the other hand Justice Hariharan termed this exception as constitutional and not illegal in nature. So the first line of argument that was advanced by the petitioner in this matter was that there is no rationale to differentiate between married men and unmarried men. So with this argument, what they meant was that once it is established that the offence of rape has been committed, once the provision of section 375A to D are satisfied with, then there is no logical reason to not term that particular offence as a rape only because that the accused person was married to the victim. इस बात से फ़र्क नहीं पड़ना चाहिए कि जो अक्यूज़ था वो उसका हस्बैंड था। अगर ये चीज़ प्रूव हो गई है कि 375 ए से लेकर 375 डी के प्रोविज़न अट्रैक्ट हो रहे हैं, क्योंकि इससे ये हुआ, इसका मतलब ये हुआ कि रेप का ऑफेंस तो कॉन्स्टिट्यूट हो गया है ना। एक बार जब ये चीज़ हम कंक्लूसिवली डिटरमाइन हो गई है, तब सिर्फ इस बात से फ़र्क नहीं पड़ना चाहिए और इस वजह से सिर्फ एक अक्यूज़्ड को नहीं किसी को नहीं छोड़ना चाहिए क्योंकि जस्ट बिकॉज वो लीगली मैरिड था विक्टिम से। ये so this was the first line of argument. The second line of argument was that कि मैरिज शुड नॉट बी अ रेलिवेंट कंसिडरेशन ये कंक्लूड करने के लिए कि कोई क्रिमिनल ऑफेंस कमिट हुआ है या नहीं हुआ है। अब अगर कोई क्रिमिनल ऑफेंस किसी ने कमिट किया है, वो क्रिमिनल ऑफेंस कोई भी हो, मर्डर का हो, रेप का हो या फिर कोई भी ऐसे क्राइम अगेंस्ट बॉडी हो, तो ये कंक्लूड करने के लिए कि कोई क्रिमिनल ऑफेंस कमिट हुआ है या नहीं हुआ है, मैरिज को बीच में नहीं लाना चाहिए। मैरिज एक सेपरेट एक्टिविटी है जो दो लोग के बीच में परफॉर्म हुई है, बट उस मैरिज के होने के बाद अगर कोई किसी भी पार्टी के द्वारा, हस्बैंड या वाइफ के द्वारा अगर कोई क्रिमिनल एक्ट किया गया है अपने पार्टनर के अगेंस्ट, तो क्या सिर्फ इस वजह से कि उन दोनों के बीच में मैरिज सब्सिस्ट कर रही है, क्या उस क्रिमिनल कॉन्डक्ट को हम लोग को वेव ऑफ कर देना चाहिए? विल इट बी राइट थिंग टू डू सो? This was the second line of argument. The third line of argument was that this particular exception of marital rape is not in consonance with with gender equality concept. With this, they meant that see, if you really are concerned about you know gender equality and women empowerment, then you cannot let go a man who has committed crime against a particular woman only because of the reason that that particular accused person was married to the woman, because in then what will happen that that particular woman will always have to live with the with that depression and remorse throughout her life, and as an individual she will never be able to grow in her life. And so this was the third line of argument. The fourth line of argument advanced by the petitioner was that अक्सर ये कहा जाता है कि अगर हम लोग मैरिटल रेप के एक्सेप्शन को अनकॉन्स्टिट्यूशनल डिक्लेयर कर देंगे या फिर मैरिटल रेप को एज एन ऑफेंस रिकग्नाइज कर देंगे, तो फॉल्स केसेस के फाइल होने की जो प्रोबेबिलिटी वो बढ़ जाएगी। बट इसका मतलब ये नहीं है कि अगर कोई एक्चुअली में ऑफेंस कमिट हुआ है, वो भी रेप जैसा ऑफेंस, तो सिर्फ इसलिए क्योंकि देर आर चांसेस ऑफ फाइलिंग ऑफ फॉल्स केसेस, हम लोग एक भी पर्टिकुलर ऑफेंस जो एक्चुअली कमिट हुआ है उसको हम लोग नज़रअंदाज कर दें। ये प्रॉपर, दिस इज नॉट व्हाट द जस्टिस डिमांड्स। एंड इफ एनी इवन इफ अ सिंगल wrongful act has been committed by any person, then it is the right thing to do is that that person should come to terms should come in terms with the justice system. So the fifth line of argument that which was advanced by the petitioner was that marriage is something which only gives sanction, which only gives social sanction between adults to perform sexual activities, but it does not give the permission to any individual to force oneself upon the other. इसका मतलब ये हुआ कि मैरिज एक ऐसा इंस्टीट्यूशन है जो कि एक सोशल एक्सेप्टेंस देता है दो पार्टनर्स को, दो इंडिविजुअल पार्टनर्स को टू परफॉर्म सेक्सुअल रिलेशनशिप। ठीक है, बट इसका मतलब ये नहीं है कि एक पार्टनर दूसरे पार्टनर को आपको उसकी मर्जी के अगेंस्ट उसके ऊपर यू नो फोर्स करेगा सेक्सुअली। और इस पर्टिकुलर केस में इसका यही मतलब है कि मैरिज एक ये रीज़न नहीं होना चाहिए किसी भी द मैरिज शुड नॉट बी द रीज़न इनफ फॉर अ मैन to force himself upon her wife. And the sixth line of argument, which is linked with the fifth one, is that marriage is not, which the petitioner advanced in the court, is that uh, marriage is not a license to ignore consent, and uh, and also that there is a right to bodily autonomy. So when we talk about the offense of rape, so the most important ingredient in the offense of rape is that the particular sexual activity should have been committed without the consent of the person, without the consent of both the persons involved. And marriage should not be taken as a reason to grant to imply a general consent to for anybody to perform or force oneself onto the other. So marriage should not be considered as ignoring the important aspect of consent in a sexual relationship. And also, since everybody has a right to bodily autonomy, and such bodily autonomy is also uh, attached with a female's body. So even if the two partners are in a marital relationship, it should not mean that any man can force himself against his wife and forego her right to bodily autonomy. So these were the arguments that were advanced by the petitioners in the matter for declaring, for seeking the court to declare that the marital rape exception is unconstitutional and is illegal in nature. And so the basic crux of the arguments that were advanced by the petitioner was that this particular exception is a violative of Article 14 because it is arbitrary in nature and is not backed by any reason, and it is also violative Article 15 because it is a statute or it is a provision which is discriminatory, which discriminates women on the basis of sex and gender. So these were the arguments that were advanced by the petitioners. Now we'll come to the arguments that were advanced by the respondents and the interveners in the matter. So the first argument that were advanced by the respondent side is that uh, courts cannot create a different set of offense. So what the respondent in this matter said that what the petitioner is asking the court to do is to create a different offense in itself, which the court does not have the right to do so on account of the principles of separation of powers. So separation of powers deals with different powers that different organs have with itself. So since court does not have the power to create any law, therefore, if the prayers of the petitioners are you know are granted by the court, then what will happen is different set of offense will be created by the court, which will in the form of recognizing marital rape as an offense. And this particular thing, this particular relief cannot be granted by the court since it will amount to creation of a new law. So this was the first line of our defense that was uh, advanced by the respondents. Also, the respondents and the interveners argue that if the courts will itself declare marital rape exception as unconstitutional and will recognize it as an offense, then the participation of public in the lawmaking procedure will fail, and this will also be violative of the concept of separation of powers, because in our country the laws are made by the participation of people when in and even by the participation of people uh, in the form of the representatives elected by them and elected by them in various assemblies and the parliament. So if the courts will itself will grant the relief sought by the petitioners, then it will also violate the role of republic in lawmaking procedure in this country. The third line of argument that was advanced by the respondent was that non-consensual sex is already criminalized under IPC under various provisions of law. So तो इसमें respondents ने ये कहा कि already सेक्शन 498 AIPC और डोमेस्टिक वायलेंस एक्ट के अंदर ऑलरेडी सेक्सुअल क्राइम्स जो हैं वो ऑलरेडी पेनलाइज्ड उनको करके रखा हुआ है, इसलिए फोर्स्ड सेक्सुअल एक्टिविटीज़ जो भी परफॉर्म होती हैं अगेंस्ट वुमेन उनको उनको क्योंकि ऑलरेडी एक आइडेंटिटी मिली हुई है अंडर डिफरेंट स्टैट्यूट्स एंड प्रोविजन, इसलिए इसलिए मैरिटल रेप एक्सेप्शन को जो कि सेक्शन 375 में दिया हुआ है उससे कोई भी इंटरफेरेंस करने की ज़रूरत नहीं है, बिकॉज इसका ध्यान दूसरे प्रोविजन और दूसरे स्टैट्यूट ऑलरेडी रख रहे हैं. The fourth line of argument that was advanced by the respondents in this matter was is that you know the petitioners in their contention said that see in triple talaq also the court has held the system of triple talaq biddat as unconstitutional. So here also the courts can grant the similar relief and can term the marital rape exception as unconstitutional. But what the respondent in reply said that although ट्रिपल तलाक को अनकॉन्स्टिट्यूशनल डिक्लेयर किया गया था, बट ट्रिपल तलाक के रिगार्डिंग लॉ कोर्ट ने नहीं बनाया था, वो काम कोर्ट ने लेजिस्लेचर के लिए अलग से छोड़ा था, जिसके बाद एक एक्ट भी आया था. बट यहाँ पे क्या होगा कि अगर मैरिटल रेप एक्सेप्शन कॉन्स्टिट्यूशन डिक्लेयर कर दिया और उसका एम्बिट बढ़ा दिया, तब अपने आप में मैरिटल रेप एक्सेप्शन एक लॉ बन जाएगा जो कि कोर्ट नहीं कर सकता है, क्योंकि वो लेजिस्लेचर का काम है करना. सो बेसिकली द रिस्पोंडेंट की साइड के आर्ग्यूमेंट का क्रक्स यही था कि फर्स्टली तो कोर्ट के पास पावर नहीं है अंडर आर्टिकल 226 टू क्रिएट अ डिफरेंट सेट ऑफ ऑफेंस, एंड दूसरा ये कि ऑलरेडी डिफरेंट प्रोविजंस ऑफ लॉ डिफरेंट स्टैट्यूट्स में नॉन कंसेंशुअल सेक्स को ऑलरेडी क्रिमिनलाइज करके रखा हुआ है, इसलिए मैरिटल रेप एक्सेप्शन को में पेंट से इंटरफेरेंस करने का इस समय कोई मतलब नहीं है. This was basically the crux of the arguments advanced by the respondents. We'll discuss the decision delivered by Justice Chakdar in his judgment. So Justice Chakdar actually declared this marital rape exception as unconstitutional and illegal. So what were the grounds upon which he did so? So the first ground upon which the first ground of the respondents that he answered was that separation of power is although intrinsic part of the Constitution of India, but USA की तरह इंडिया में स्ट्रिक्ट और रिजिड तरीके से सेपरेशन ऑफ पावर्स एक्सरसाइज नहीं होता है. इसलिए रिस्पोंडेंट्स का ये कहना कि क्योंकि यहाँ पे सेपरेशन ऑफ पावर है, इसलिए जुडिशरी यहाँ पे इस एक्ट को का एम्बिट नहीं बढ़ा सकती. वुड बी अ रॉन्ग थिंग टू डू सो, टू से सो. एंड ऑल्सो बिकॉज यहाँ पे वायलेशन ऑफ फंडामेंटल राइट का मामला है, जैसे कि पिटिशनर ने कंटेंट किया है, इसलिए बेस्ड ऑन दिस रीजन ये कहना कि कोर्ट के पास इस मैरिटल रेप एक्सेप्शन से इंटरफेरेंस करने की कोई पावर नहीं है, ये गलत होगा. और इन वजहों से कोर्ट ने रिस्पोंडेंट्स का कंटेंशन रिजेक्ट कर दिया था. ऑल्सो इसमें कोर्ट ने ये कहा था कि एक्सेप्शन जो 2 है सेक्शन 375 आईपीसी का, जो मैरिटल रेप के बारे में बात करता है, उसका कोई रैशनल नेक्सस है नहीं उसके ऑब्जेक्ट से. अब अगर कोई अब रैशनल नेक्सस क्यों नहीं है उसके ऑब्जेक्ट से, उसके लिए कोर्ट ने ये कहा कि जो डिफरेंशियल ट्रीटमेंट दिया जा रहा है एक हस्बैंड को विद रिस्पेक्ट टू द ऑफेंस ऑफ रेप, इसका कोई प्रॉपर जस्टिफिकेशन पार्लियामेंट द्वारा नहीं दिया गया है टू मेक इट एज एन एक्सेप्शन टू द ऑफेंस ऑफ रेप. बिकॉज अगर सेक्शन 375 का अपने आप में ये ऑब्जेक्ट है कि रेप का ऑफेंस क्रिमिनलाइज्ड हो, तो उसने एक्सेप्शन टू देके कॉन्ट्राडिक्टरी व्यू क्यों ले लिया कि एक पर्टिकुलर अक्यूज्ड पर्टिकुलर काइंड ऑफ अक्यूज्ड होगा जो कि मैरिज के इंस्टीट्यूशन में इन्वॉल्व होगा, वो उसको एक 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 सेफ हेवन क्यों दिया है. ये जो एक्सेप्शन है इसलिए आर्बिट्ररी है और इसका कोई रैशनल नेक्सस नहीं है with the primary object of the of section 375 IPC. Also, Justice Sagdar has stated in his judgment that कि फॉर एग्जांपल अगर एक ऐसी सिचुएशन ले लीजिए कि कोई गैंग रेप का केस हो और उसमें एक अक्यूज्ड हो जो कि स्ट्रेंजर हो और एक अक्यूज्ड हो जो कि हस्बैंड हो, को अक्यूज्ड. तो एक को अक्यूज्ड हस्बैंड, एक को अक्यूज्ड स्ट्रेंजर है. तो क्या इस सिचुएशन में हम लोग हस्बैंड को सिर्फ इसलिए छोड़ देंगे क्योंकि वो हस्बैंड था विक्टिम का? क्या ये सही चीज़ होगी करना? और क्या हम सिर्फ इस रीज़न की वजह से दोनों के अक्यूज्ड को अलग अलग पनिशमेंट देंगे? तो ये अपने आप में एक बहुत ही अनरीजनेबल सिचुएशन है कि जस्ट बिकॉज एक को अक्यूज्ड हस्बैंड था इसलिए हमने सेम एक्ट के लिए दो लोगों को अलग अलग पनिशमेंट दी. Also, the Justice Akbar also further stated in his judgment that key in today's world where sex workers also have the right to say no to the sexual activities. Why can't the wives have the same liberty to same liberty and right as the sex workers do have in this country as of now? So also based on this reason also uh, the Honorable Justice Chakdar has held that this particular marital rape exception is unconstitutional and not legally valid. Uh, Also, there were also a few other grounds that was taken by Justice Chakdar to term this marital rape exception as unconstitutional. Uh, the other ground stated by the respondent regarding the finding of probable false cases was negated by Justice Chakdar by stating that फॉल्स केसेस का एक तो कोई एम्पिरिकल डेटा है अवेलेबल नहीं है, ना ही रिस्पोंडेंट्स ने कोई डेटा प्रोजेक्ट या प्रोड्यूस किया था बिफोर द कोर्ट अपने आर्गुमेंट्स को स्ट्रेंथन करने के लिए. ऑन द कॉन्ट्ररी, जस्टिस अकबर produced some data wherein it was shown that in 99% of sexual violence cases goes unreported. कि जो भी सेक्सुअल वायलेंस के केसेस होते हैं जो डोमेस्टिक इन नेचर होते हैं, जो एक घर के अंदर होते हैं या किसी मैरिज के मैरिटल बेसिकली जो मैरिटल रेप के जो भी इंसिडेंसेस होते हैं वो 99% ऑफ द टाइम अनरिपोर्टेड रहते हैं. तो अगर इतना बड़ी चंक ऑफ केसेस अनरिपोर्टेड जाते हैं तो इससे हम लोग ये कंक्लूड कर सकते हैं कि फॉल्स केसेस तो शायद हो या ना हो, वो तो फ्यूचर की बात है, बट एज ऑफ नाउ इतने सारे क्राइम्स अगर अनरिपोर्टेड जा रहे हैं तो विल इट बी अ गुड थिंग फॉर सोसाइटी टू लिव थ्रू इट, और सो based on this reason also the Honorable Justice Shakdar stated that this particular marital rape exception should not hold ground, does not hold ground. And regarding the contention of the respondent that a new offense will be created if the marital exception is criminalized. So here Justice Shakdar stated that by this judgment he is not making any effort to create a new law, but he's only elongating or extending the scope of Section 375 uh, uh, in the among the institution of marriage also. So this was the basic premise, basic reasoning upon which Justice Shakdar, held that the marital rape exception is unconstitutional and invalid. Now, we'll discuss the grounds taken by Justice Hariharan to term marital rape exception as not unconstitutional and not illegal. So, I'll give you a basic reasoning stated by Justice Hariharan in terming the marital rape exception as not unconstitutional, was that he said that there is an intelligible differential between a married man and an unmarried man committing the offense of rape. Wherein to elaborate this argument, he stated that you know he projected two different scenarios wherein he stated that let's take two different situations where in one situation an offense of rape has been committed by a complete stranger against a woman, and in one situation an offense of rape has been alleged against the husband of the victim. So these two different, the Justice Hariharan said that these two situations cannot be measured with same standards, because while it is very easy for in because in the case where the accused was a stranger, there was no expectation of sexual relations between the victim and the accused. However, where the accused was the husband, there was an expectation of sexual relations between the accused and the victim because of the institution of marriage. So this is the defining criteria between the difference between the acts committed by a complete stranger and the act committed by husband against the woman as is alleged by the victim. So that was the logical reason suggested by Justice Hariharan to differentiate between these two situations, and therefore he termed that marital rape exception is not unconstitutional, and it also work towards protection of the institution of marriage, which is a very important feature in the Indian society. So this was actually the only when you go through the judgment, you'll find that the reasons of Justice Hariharan revolved around this reason revolved around these points only, where for terming the marital rape exception as not unconstitutional. And so this was all about the split verdict that was delivered by the Delhi High Court. So आफ्टर अब इस जजमेंट को डिस्कस करने के बाद हम लोग के दिमाग में बहुत सारे क्वेश्चन आ रहे होंगे कि किस जज ने विच ऑफ द टू जस्टिसेस हैव टेकन द करेक्ट व्यू. सो दैट इज अपॉन you all to decide for yourselves that you will go on which side of the you will take whose side in this matter. But it is uh, for for any layman, in India, since you all know that marriage is considered a very sacred institution and everything. So, do you all still think that this is a proper time to criminalize the offense of marital rape, or do you think that as we see that yes, there are instances of false cases being filed by the women against men under 498 IPC and under Section 304 BIPC, etc. So, in light of these things, do you all still think that the marital rape exception should be criminalized, or it should be decriminalized? So, post your opinions in the comment section, and I will, give try to give a rebuttal of your suggestions in the comment section itself, and we'll try to have a healthy discussion on this topic in the comment section. And if someone would likes to uh, share their opinions with me personally, they can also contact, and we will definitely elaborate on this topic for academic purposes. So thank you, and this was all in this particular video.